Under the non-delegation doctrine, Congress can't delegate its legislative power to a regulatory agency without dictating clear guidelines about how the agency can exercise that authority. It's an implicit rule derived from the Constitution's separation of powers design. American Trucking Associations versus Environmental Protection Agency raised the question of whether the Clean Air Act delegated too much power to the Environmental Protection Agency, or EPA. Under the Clean Air Act, or CAA, the EPA must set and regularly revise national ambient air quality standards, known as NAAQS, for certain air pollutants. The EPA must set primary and secondary standards for each pollutant. The primary standard is the concentration level, quote, requisite to protect the public health, unquote, whereas the secondary standard is the level, quote, requisite to protect the public welfare, unquote. In 1997, the EPA issued rules revising the primary and secondary NAAQS for ozone and particulate matter, known as PM. Ozone and PM are nonthreshold pollutants, which means that they have the potential to cause adverse health impacts at any concentration level above zero. In establishing the NAAQS for these pollutants, the EPA considered the severity of the potential health effects, the certainty of those effects, and the size of the population likely to be affected. After considering these factors, the EPA lowered the primary NAAQS for ozone from 0.09 parts per million to 0.08 parts per million. American Trucking Associations and several other organizations petitioned the D.C. Circuit for review of the EPA's proposed new rules.